Thank you for watching. My name is Advocate Muhammad Abduroaf, and today's topic relates to the issue of whether or not you require to have a lawyer, an attorney, or advocate in a legal matter. Now, the quick answer is no. You are entitled to represent yourself in any legal matter by yourself. You can sign legal documents yourself. You can represent yourself in court. You can argue in front of the judge or the magistrate yourself. So that's the short answer and the proper answer. But how does it work? Now, when do you get a scenario whereby can you represent someone else? No, you can't. You need to be an attorney or an advocate to represent a client in court, but you are entitled to represent yourself. Now, this question comes to me a lot when people receive legal documents. And in the sphere of civil litigation, if, for argument's sake, you owe someone money and that person goes to an attorney and they issue a summons out of the court and they serve the summons on you. Let's say you owe somebody $100. That's my scenario. You are entitled to file your notice of intention to defend and sign it and send it to the other side and file it at court. You are entitled to file your own plea and with a counterclaim if need be and sign it and send it to the other side. You can even consult with an attorney first or an advocate first. They can assist you in drafting the specific documentation and then you can sign it yourself because you are responsible for that. The same applies for applications. Let's say there is an eviction application. You can defend it yourself. You can file your own opposing affidavit, etc. You can even institute court proceedings on your own. You do not require an attorney or an advocate for that specific purposes. You're allowed to do it on your own. So in my example of an eviction, if you have a tenant and the tenant does not want to leave your premises, you are entitled to draft documentation and issue it and file it at court and serve it on the other side. But in the same breath, if you are not familiar with the legal proceedings, with how the courts work and how legal documentation should be drafted and the procedures and the rules, etc., it's not advisable for you to do it on your own. And I'm just saying that because logically speaking, if I'm a mechanic, I'll know how cars work, etc. Uh, Someone who knows nothing about how cars work and how it operates and how to fix it, they shouldn't be under the bonnet. It doesn't make sense. But you are allowed to do it, if you know what you're doing. I advise you to do so. But if you do not know what you are doing, please get an attorney or advocate to assist you where that is concerned. Now you get the other sphere, for example, family law matters and criminal matters, but I'll deal with family law first. Like an application for child maintenance, you can do it yourself. You do not require an attorney. If the other side comes with an attorney at court, it might be a good idea for you to now employ the services of an attorney to assist you because the other party might know the rules better, know how to present information, know how to cross-examine quite well, how to and you might come to court with a certain view on how procedures should take place, what evidence to present and submit, but it might not be the proper way. Therefore, it might be a good idea for you to obtain legal representation in that specific scenario. The same applies for arguments like domestic violence matters. You can represent yourself, divorce matters, etc. On criminal matters, yes, you're allowed to represent yourself in criminal matters at any time. But I strongly don't advise you to represent yourself in criminal matters, especially so where the consequences are great. For argument's sake, let's say you're charged with a serious offense and there's a potential of you going to prison. Doesn't make sense. Get an attorney, get an advocate, get someone to represent you and assist you legally in your legal matter. If you cannot afford legal representation, there is a legal aid board and various other places that might do work for the bono for you if you qualify, etc. But that is my advice to you. If you mess it up, and that is technically possible, for argument's sake, you file your affidavit, but you do not stipulate specific clauses in your affidavit. For example, say you know take an oath, and the contents hereof are within your personal knowledge and both true and correct unless the context says otherwise. You prepare your affidavit at the end, where the signature is. There is no part where the commissioner should sign. So obviously you have your answers, but you do not necessarily know how to prepare the specific documentation. The same might, for example, apply with drafting court documentation like a notice of motion or summons. There might be certain requirements that you might not be familiar with. So I advise you maybe under those circumstances make use of an attorney. But if you know what you're doing and you've done the research, you looked up online, and it's quite simplistic, and the consequences is not that great, then of course, why not? If we can save some money, but first prize would be to make use of legal representation. So the long and the short of the matter is you can represent yourself, no need for a lawyer, attorney, or an advocate, but at the same time, it's better if you do make use of these services. Thank you very much.